In this video, we are going to be talking about a critical Supreme Court emergency election order that was just issued. So let's talk about what has happened. Now, really quick before we jump into this video, I want to thank one of the main supporters of this channel, which is Brownells. Brownells, as many of you guys know, is an amazing company. You can pretty much purchase any, the Pew Pew products that you want. Huge 2A supporters. I got to spend some time out with them over in Iowa. Just great people. So if you want to get some amazing products, check out Brownells. I can't link to them, but if you use the code SCHOLAR10 when you purchase, you can actually get 10% off of your order. So thank you again to Brownells for sponsoring and supporting this content. As I mentioned in the intro, in this video, we're going to be discussing another huge election decision that just came out of the United States Supreme Court. This case we're going to be discussing is a case called Genser versus Butler County, and it involves an attempt to block a ruling by the Pennsylvania Supreme Court, and that decision there that allows the count of provisional ballots which are submitted by voters who had mail-in ballots that were found and essentially deemed to be invalid. In this case, the United States Supreme Court was asked to intervene on an emergency basis, but the Supreme Court just issued a late emergency order which denied that emergency intervention. So we need to talk about what this case did, what it's involving, and then also what the order of the Supreme Court was. In this case, the RNC and the Pennsylvania Republicans sued and argued that the state Supreme Court there in Pennsylvania had dramatically changed the rules governing mail-in voting and mail-in ballots. They argued that the state Supreme Court had violated the United States Constitution by usurping the state legislators' role in regulating federal elections. In this case, there was an argument about mail-in ballots, discrepancies, or invalid mail-in ballots then leading to provisional ballots, and whether or not provisional ballots should actually be counted. The petitioners argued that this decision can impact tens of thousands of votes in the state of Pennsylvania, and possibly even the outcome of the presidential election because of the critical swing state of the state of Pennsylvania. In Pennsylvania, voters using mail-in ballots are required to seal their ballot in an envelope known as the secrecy envelope, and then it's placed in a secondary envelope, a second envelope known as the declaration envelope that must be signed and dated by that individual. If a ballot sorting machine determines that the ballot is naked, aka that it has no secrecy envelope, that it wasn't signed and dated properly, well then the voters are notified that they have cast a potential improper ballot and that they can cast a new vote through the provisional vote at a polling place during the election. Now, this case started because two voters who had provisional ballots which were not counted during the state's 2024 primary election, they went to state court and they argued that the election board was required to count their ballots. Now, this case eventually made its way to the Pennsylvania Supreme Court, and the Pennsylvania Supreme Court issued a 4-3 decision. In that decision, the Pennsylvania Supreme Court agreed that if the mail-in ballots are not counted, well, then the provisional ballots must be counted. In response, the petitioners here have now filed for Supreme Court emergency intervention and review. They have filed for a writ of cert along with a request to stay that Pennsylvania Supreme Court order because they do not want this to be counted this way. And also they asked for some other things in the alternative, essentially setting aside some of these ballots and counting them separate so they could track which provisional ballots were actually taking place in some of these areas. And ultimately, if those provisional ballots were found invalid, they wanted to keep track of all those items. Now, also in their request to the Supreme Court, they asked for an emergency administrative stay to be issued and put in place before November 5th to maintain the status quo before the election, and essentially up until the Supreme Court could actually review the merits of the case if they wanted to review the merits of this issue. In the petition, they argued that weeks after mail-in voting began in Pennsylvania and less than 2 weeks before Election Day, a sharply divided 4-3 Pennsylvania Supreme Court departed from the plain terms of the election code to dramatically change the rules governing mail-in voting. It did so in the midst of an ongoing general election in which millions of Pennsylvanians have already cast ballots for president, U.S. Senate, Congress, and scores of state and local offices. They state that the election code provision at issue could not be clearer. A provisional ballot shall not be counted if the elector's mail-in ballot is timely received by the County Board of Elections. Undeterred, the majority below held that the election officials must count a provisional ballot cast by an individual whose mail ballot was timely received but could not be counted because it violated a mandatory rule, such as a lack of signature, date, or a secrecy envelope. This holding effectively creates a cure process for mail-in ballot errors, a process everyone agrees that the General Assembly has deliberately chosen not to create. As the three dissenters recognized in the Pennsylvania Supreme Court, On this question, the election code is clear and unambiguous. They state that the Supreme Court bears the constitutional responsibility of ensuring that state courts do not unconstitutionally intrude upon the role specifically reserved to the state legislators in the United States Constitution. When the legislator says that certain ballots can never be counted, a state court cannot blue pencil that clear command into always. The main contention in this case, in this petition to the Supreme Court, is who has the authority to authorize a do-over for voters and if one is even permitted. The argument of the RNC is that allowing the voters to cast a provisional ballot would be an amount to a ballot curing, and it would allow essentially a second shot when someone has a clear error. They should have maybe done it right the first time. And what happens if there's an error? Who can correct that? And if those ballots can be counted. In the emergency petition, they asked for the Supreme Court to place at least an administrative stay on the Pennsylvania Supreme Court decision until the United States Supreme Court could actually review this issue. They asked for the Supreme Court to place an order that would then segregate the provisional ballots and also not place them in the official vote count. So they wanted them separated even if this was allowed to move forward so that they could track these provisional ballots. Well, late Friday night, we got an order from the United States Supreme Court and they denied that emergency request. There was a brief opinion statement that was issued by the United States Supreme Court in this denial. It was written by Justice Alito and then joined by Justice Thomas and then also Justice Gorsuch. This opinion in the denial states that the application for stay presented to Justice Alito and by him referred to the court is denied. This case concerns a recent decision of the Supreme Court of Pennsylvania that adopted a controversial interpretation of important provisions of the Pennsylvania Election Code. Specifically, the court held that a provisional ballot must be counted even if the voter previously submitted an invalid mail-in ballot within the time required by law. The applicants contend that this interpretation flouts the plain meaning of the state election code and that the interpretation is so far afield that it also violates the election clause and the electors clause of the Constitution of the United States. To prevent county electoral boards from following that interpretation in next week's election, the applicants ask us to stay that state Supreme Court judgment, or at least to order the sequestration of ballots that may be affected by that interpretation. The application of the state Supreme Court's interpretation in upcoming elections is a matter of considerable importance, but even if we agreed with the applicant's federal constitution argument, a question on which I express no view at this time, we could not prevent the consequences they fear. The lower court's judgment concerns just 2 votes in the long-competed Pennsylvania primary. Staying that judgment would not impose any binding obligation on any of the Pennsylvania officials who are responsible for the conduct of this year's election. And because the only state election officials who are parties in this case are the members of the Board of Elections in one small county, we cannot order other election boards to sequester affected ballots. For these reasons, I agree with the order denying the application. So here you have Justice Alito saying that maybe he agrees with some of the arguments being made here, and maybe some of the other justices agree that a stay could potentially be issued, and that this Pennsylvania Supreme Court decision was incorrect. But he's pointing out that the lower court decision was only in regards to 2 individuals who had some voting issues during the primary election, and that the officials included in this specific case, the Pennsylvania officials, were very narrowly, they're individuals who are just in one specific county. So any type of relief that they granted would only affect that county and maybe just those 2 individuals. And the broader request to issue some sort of stay and halt the impact of that Pennsylvania Supreme Court decision for all of Pennsylvania is just too broad, and they're just simply not the proper election officials who are included in this lawsuit where a type of relief like that could be granted. The court believed in this case that they could not place the binding order on any other Pennsylvania officials or counties since they were not parties to this challenge. So again, very interesting. We got an emergency order late Friday night by the United States Supreme Court on this Pennsylvania election issue. It's going to be interesting to see how this plays out. I suspect that there's going to be other lawsuits that are likely filed that are challenging what's going on here in Pennsylvania. We're going to see even more election cases probably be issued here very soon in the lead up to the election. And then also, I suspect that we're going to get even more election lawsuits that start to fly even after the election. I'm sure there's going to be a ton of challenges in various states like Pennsylvania and others. We've seen some in Wisconsin, Michigan, and others. And I suspect that this is going to grow in more importance because I think maybe some of these areas, especially in swing states, are going to be closer than people anticipate. And because of that, we're going to see some challenges to issues like this. So that's what happened in the Pennsylvania election case. I wanted to bring this to your guys' attention because we got an emergency order from the Supreme Court late Friday night. And if anything else develops, I will let you guys know. Also, if you like this video and you like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.